Good morning, everyone. Welcome to this King's Chambers Business and Property webinar on remote hearings and effective preparation. I'm Andrew Singer. I'm a member of King's Chambers and of the Business and Property team, as is my colleague Lucy Wilson-Barnes. We're both going to be speaking to you this morning, but Lucy's going to speak first. As you can probably see from the screen, on e-bundles, practicalities and litigants in person. I'm going to speak about effective advocacy and other matters like platforms. Please, if you do have questions, could I ask you to use the Q&A rather than the chat? Just so we can have all the questions in one place. We'll try and answer some of your questions at after we've both spoken. I should let you know that this session is being recorded and it will go on the King's website. Likewise, the slides that we're both going to be talking to, or in my case, probably around, will also be sent out to you. Thank you in advance for your attendance, and I'll leave you for now in the very capable hands of Lucy.
Good morning, everyone. You'll see from obviously my first slide and the topics I'm going to be dealing with. Practicalities is the first topic I want to deal with. These are very basic and common sense points, really, but they're easily overlooked by all of us. First of all, connectivity. Check well before. Generally, my experience, there will be a fairly long lead-in time from the court as to what is the platform for which the remote hearing is taking place. Usually it's Teams, but of course there can be others. Or of course it may be BT Meet Me or something of that sort. Usually it's possible to do a dummy run, as it were, just to check you have connectivity and check that everyone involved has the relevant apps or software to deal with it. Lighting, do a test run. It's important to check this to make sure that you can be seen, that you're happy with your backgrounds. You'll see from my background, effectively it's my dining room. It's important to check this with you and also your clients. I've had situations where there's, perhaps it can be said, a somewhat inappropriate background, not deliberately so, but it's important to check that there's something either is neutral or not sort of advertising the department from which your client belongs, something that's not going to cause too much of a distraction during a hearing. Obviously, the court stresses at the outset of a hearing, make sure that the parties are in a quiet, private place. Despite this, generally there are often interruptions. I've had cases, hearings where there's been interruptions, the judge has been interrupted. It happens to everyone, it can do. But it's often worth saying to the client, make sure you've got a notice on your front door, just to avoid people ringing the doorbell. And also, if it's within, obviously, a closed door within someone's house, make sure there's a notice on the door, stop other people coming in. It's easily done. All those things are worth stressing before the hearing, just to avoid those glitches. One issue that I've had is that of rogue cameras. No one really wants to see an observer or a witness who's waiting to give evidence, or someone within the client team on screen because they haven't turned off their camera. On their mobile, taking business calls. They're muted, but nonetheless one can see them doing their general work activities. And I've had a situation like that where I had to send repeated messages through the client solicitor saying, can you tell so-and-so to turn his camera off? And so it's worth giving this guidance out to people who are going to be participating well in advance of the hearing itself. Then communication. This is usually, it's something that's at the heart of a hearing, because of course you're not going to be able to turn around and get instructions or tap someone on the back to give instructions or pass a post-it note, as it were. Usually most solicitors, barristers and clients are happy to sign up to a WhatsApp group so that there can be live real-time communication depending on what's happening in court. Email also works as well, providing everyone can access that relatively quickly. My experience is most people steer clear of Teams chat because there's the concern that actually it might go wrong and that everyone else in the hearing, judge and the other side, can see the chat. So I've not actually taken part in Teams chat, and I don't see much appetite from clients or anyone else to do it. WhatsApp seems to be the preferred course. Mute. It's something that Andrew will reiterate as well. It's a basic point, but it's easily overlooked. We've probably all got horror stories of situations where someone hasn't muted. I had one where in the middle of cross-examination, a particular question was being pressed and the witness didn't answer, but from somewhere, someone gave a very exasperated response. And there was a moment where everyone paused thinking, who said that? And at some point, I think the witness said, who said that? It was someone on the legal team who hadn't muted and was letting vent their frustration at how the evidence was going. My experience, it can be legal professionals who fail to mute, and it's more likely that that's going to cause embarrassment because it's more likely that it's either the barrister or solicitor who's talking to themselves or commenting on what's going on in the proceedings. But equally, one does have situations where you can hear dogs barking in the background. It's easily done, but it's worth stressing to everyone involved, just check that you're muted. Live evidence. It's a point that's evolved in my experience through the remote use of remote hearings. At the outset, I had a trial sometime last year where my solicitor understandably started trying to make arrangements to make sure all of our witnesses had their appropriate holy book and they'd had them delivered to them through Amazon. That's not necessary. Of course, it's evolved. The court takes control of all of that and does it very efficiently in my experience. But it's worth advising the witnesses that this is how it's going to happen. Check what materials they're planning to have when they give evidence. It's somewhat difficult because in the usual course, you'd simply call someone to the witness box, they'd have the bundle. They might have an aide-memoire of corrections they want to make. No one takes objection to that. But it's rather different where someone's in their own home. And of course, no one really knows what materials they may have. Of course, giving evidence isn't a memory test, but nonetheless, it's somewhat unorthodox to have extensive notes to remind someone what they might want to say in giving their evidence. I've had cases where there's a protocol which goes backwards and forth between legal teams as to what materials should be there. It's probably safer simply just to have the trial bundle and to reiterate that's really what you need in front of you. Lighting of a witness's room. It's actually a very important point in relation to live evidence, and I had it recently that there's a risk of it unsettling the witness before they give their evidence. Bear in mind that a judge listening to live evidence in a remote hearing, it's no different from an in-person hearing in a courtroom. The judge needs to assess the witness's demeanour, and to that end, it's extremely important that the judge can see the witness close up and clearly, and see their expressions and see how they give their evidence. It's a point that I don't think I'd really addressed or had experience of until fairly recently, but it took some 10 minutes for the judge to be satisfied that the witness was lit up properly and he could see his face. And it can, as I say, unsettle a witness because they're then trying to mess around with cables and light fittings, and it's the last thing they want to have to do just before they give evidence, particularly as in most of our hearings, they're going to be cross-examined fairly quickly after they've confirmed their evidence. So it's worth addressing that beforehand with the clients and witnesses to check that they can be seen, and from the observer, there's a clear and well-lit impression that's being given. Another practicality, documents which may need to be signed for. I've had this in urgent injunctions. You may need to have undertakings which are being adapted and passed to backwards and forwards, particularly where it's a litigant in person. And also there may be circumstances where there is a party, a person who's not a party to the proceedings but needs to sign saying they understand what the order is, and they as a third party may be affected by it. They may, in the ordinary course, they would normally sign something, for example, that they've had legal advice and they understand the terms of the order, they understand the consequences of not complying with it. It's very difficult to do in a remote hearing where you can't pass a document and ask someone to sign it. And so it may be necessary where, for example, if one's dealing with a litigant in person on the other side, or that there are third parties who are going to attend that hearing to bash out an order, as it were, to make sure that they have the capacity to receive documents, print them off, sign, scan them and send them back. And it's worth setting up those lines of communication well in advance of the hearing. Bundles. They can cause so much difficulty, but I think the central message I would make is it's extremely important to try and get them right. And the central message is put yourself in the position of the person who is using it. I know it sounds straightforward, but it's easily forgotten. There was a lot of guidance when remote hearings started last year at the start of the pandemic, and there was a good one from the Bar Council in April, and there were lots of local notes from local Manchester business and property courts and so forth coming out. There's a very useful one on the Courts and Tribunals Judiciary website, General Guidance on PDF Bundles, and I've taken much of this, my guidance, from that. They're all extremely useful practical points. Of course, there needs to be a single PDF which is paginated sequentially. Note, it's a point I've had recently, where a witness statement or affidavit has references to exhibit pages, for example, ABC page 29, those original pages need to be kept on the trial bundle pages so that the judge reading that bundle, if they want to look at where ABC page 29 was, can find it. It may be they have to scroll through. But there is nothing to be gained by obliterating the original pagination, because in that way, there is no way a judge can see what ABC page 29 was. They're going to have to guess. The alternative, of course, is to obliterate the original pagination, and once the e-bundle is paginated, then go back to the witness statement, handwrite in the margins, as one does in some trial bundles in any event, notate the new trial bundle reference at the point at which the witness has said ABC page 29, to show that bundle reference in the e-bundle so that a judge reading the witness statement can see in the trial bundle where that page is. It's an important point, but my experience is that most parties are happy if the original page number has not been obliterated, so they can work out where that is in the trial bundle. Bearing in mind, pagination should be done, it should be computer generated. Do not paginate in manuscript, and the reasons for that are because then the document needs to be searchable. Make sure the pagination doesn't mask any relevant detail, and equally make sure the pagination is not in a black spot on a document so that you can't really see it. The default should be documents are all at 100%. There's a particular extract from the guidance that I've referred to, the Courts and Tribunals, Judiciary Tribunals website. For bundles to be added after the file has been transmitted to the judge, it should not be assumed the judge will accept it as a complete replacement, because they may already have started to mark up the original bundle. So make inquiries as to what the judge would like to do. A substitute bundle can be made available, but pages should be added, which should be provided separately in a separate file with pages appropriately subnumbered. So in other words, don't just start again, having inserted the documents, and repaginate the whole lot. Think what the recipient would be doing. If a judge has already started marking up the bundle and they've made a note, they may have marked that bundle, the e-bundle, then to receive a new bundle, because some documents have been added, the pagination is entirely different. It's sequential. It starts from 1 to 4,000, but it's now different. That's going to be extremely frustrating for anyone who is trying to use that bundle. Bundle has to be searchable. And of course, the phrase is OCR, optical character recognition. It's the process which turns the document from a mere picture into a document where the text can be read as text, so the document becomes word searchable, and words can be highlighted in the process of marking them up. That's what judges expect. They don't want to have to scroll through the entire PDF. They want to be able to search at the top of the PDF bundle for the page number. And to that end, guidance also says it's useful to, for example, have A or B in relation to the bundle, because bearing in mind, if you simply put in a search of 413, the judge may get every document which has got 413 in it. But most bundles have at the top, of course, the ability just to put in the page number, and it will, clicking on that, it will take you straight to the page number in the e-bundle. Bookmarks for each section and hyperlinks on the index are extremely useful, but also more than that, they're essential. That's what the requirement is. The guidance tends to be, and judges generally want this, that all significant documents will also be bookmarked for ease of navigation. So if there are particular key documents and you don't have a core bundle, isolate what those key documents are and bookmark them in the index, so the judge doesn't have to keep going to page whatever, can just click on that. Dissemination, again, trying to get the bundle to the court is a massive practical headache for most solicitors. I appreciate that, and there are many problems that arise. I've been in hearings where we've all assumed, because the bundle has been sent well in advance, that the judge has it, but because possibly of the limits of the C-file system, because the bundle is too large, it just won't accept it, and therefore the judge doesn't have it. Again, the central message is there's need for ample time to make sure that the bundle has been communicated and that the judge has it. Caution when emailing it as an attachment, because of course there are court limits, and I understand that there's a maximum size of attached files can be received by a justice.com address, which is 36 megabits, and in aggregate that the amount is larger for a judiciary.net address. So it's often easier to get it directly to the judge, but of course that's not always possible. Share file, Dropbox, etc. are often the ways of communicating, and HM Court Service have their own document upload center, which you can find guidance on that on their website. I think it's a share file method, and it works quite well. No USB sticks, of course, to send an e-bundle to the court. And it's always worth having a link ready to send with a link to the e-bundle by a share file or something of that sort. If you're faced in a hearing and the judge says, as they have done to me, I just don't have the bundle, it's very helpful to have a solicitor who then says, I can send a link right now. Specific points in relation to e-bundles: only the documents which are necessary for the hearing should be attached. There is nothing to be gained, particularly on a PTR, for including all of the evidence where there may be very lengthy exhibits. It may be that one needs to have the witness statements, key orders, but think about it from the point of the recipient, i.e. from the judge who is reading through that bundle. Seek guidance from the trial judge as to how they want the bundles to be organised, because they don't automatically follow as one might imagine in a live hearing. The guidance that I've referred to, the general guidance on PDF bundles, has this, I think it's paragraph 5, it says proper thought should be given to the number of bundles required. It's generally not helpful to have to open a significant number of PDF files during the course of the hearing to get up documents. That said, I've had a case where the judge specifically wanted different PDFs, so wanted one bundle with all the witness statements, another bundle with other key documents, and then another bundle with all the exhibits. Completely dispensed with the normal documents you might have thought would be in a bundle, such as previous orders, acknowledgements of service, etc. They were very focused about what they wanted in the bundles, and it worked well. In a document-heavy case, address a core bundle and offer it. In my experience, if the court doesn't ask it, most judges will. Do it with care and be ruthless. There is nothing to be gained from having effectively a side parallel bundle which has many of the documents which are in the existing bundle. Core bundle should be just that, and of the greatest assistance to the trial judge. Lastly, I want to deal with litigants in person as a specific issue, which which can arise. I've had a lot of experience of having to deal with litigants in person over the last year, and as I say, a prospect of a remote hearing may genuinely give rise to real concerns on the part of a litigant in person. It's much more, can be much more stressful than simply having to turn up at an appointed place and make sure you're in the right courtroom. But that said, dealing with litigants in person can also give rise to what I've referred to as asserted problems. And to be blunt, they can be put forward as excuses as to why the hearing can't take place. And that's really what I want to focus on. Although, of course, the general point I would make is where there are litigants in person, you cannot be too helpful to them in making sure that they have the utmost assistance as to how to participate and how to participate effectively and fairly in the hearing. So many of the comments I make address both of those points. But as I say, my experience is really to how to avoid being the day before a hearing and having a litigant in person who says, I simply can't attend, I don't have Wi-Fi, I can't attend because it's just impossible. So general principles: make contact well in advance to check they have Teams, which is the usual platform in my experience, and that they have sufficient Wi-Fi connectivity. Actually offer to do a dummy run with them. You can set up a Teams meeting to check they can see you, they can hear you, you can see and hear them, and they're confident with how to use it. It does no harm to do that. It will flush out any excuses which are being made. And make sure that they know they need sufficient Wi-Fi connectivity. If they assert they don't, and I've had several cases where it's been trotted out as an excuse, we just don't have upload and download speeds, it's not possible, we're in a Wi-Fi zone where it's just very poor, check the local Wi-Fi speeds, check the cost and time scale of improving it, and give advice as to how that might be improved. There are lots of hints which can be given online as to how to test the Wi-Fi speed, how to get an upgrade. For example, many hints such as change the position of your router, check with your ISP, check there isn't internet throttling, I think it's called, when they effectively to avoid the rush of people streaming all at one time. Make sure background apps are shut down. Make sure it's not being shared with other people in the house who are maybe streaming or also using internet, which is going to put a strain on the connectivity. Ask all those questions and give that assistance effectively to try and avoid the prospect of a litigant in person, as I say, who simply says to you and to the court, I can't participate. Secondly, of course, make contact well in advance to make sure that they have sufficient capacity to use an e-bundle. They're confident as to how to download it from the share file or the Dropbox, whatever the method is to communicate that e-bundle. Most solicitors I deal with will offer to provide a hard copy of it to a litigant in person. We perhaps take it for granted we may be confident in using an e-bundle or have the capacity to print off what we want. Litigants in person often don't have that. Practicalities: remind them in advance of the need for a private room with a computer and internet access, which, as I say, is not to be overused, and that they're going to need to be there possibly for a long period of time. I've had practical experience where shortly before a trial, litigant in person said, my house isn't big enough. The computer is next to the baby changing mats. We've got a new baby. It's a tiny house. There's no privacy, and I simply can't deal with this hearing. As it turns out, they were all well-founded points, but the judge who dealt with it at the application to adjourn the hearing wanted effectively a remote run through this person's house to see how big it was. He asked him to explain how big it was. He wanted to take him on a virtual tour through the house. How many rooms have you got? How big are they? Why can't you go in the spare room? And during that hearing, he wanted to know, he wanted to have objective confirmatory evidence that this house was not big enough. So we did a Zoopla search and confirmed it was in fact a small house. And there were good grounds to conclude the hearing could not go ahead fairly in the circumstances, but equally often litigants will put forward what are effectively excuses. And don't be backwards at scrutinising those excuses. And my experience is the more help that is offered well in advance will flush out where they are simply excuses without foundation and where they are genuine problems. Ensure you can get documents which arise during the course of the hearings. With litigants in person, it may be that for example, you want to cross-examine on documents which aren't necessarily in the bundle, and they don't need to be in the bundle. There may be things that crop up shortly before a hearing. Make sure there are those lines of communication which are open to the litigant in person. They can receive documents, and they can also communicate documents which they have come across, which perhaps ought to be in the bundle, but which aren't, and for which we simply want to get round that practical issue to make sure the hearing can go ahead effectively. So that concludes really what I wanted to say. As I say, we'll take questions at the end of the session. I will now pass over to Andrew. Thank you.
Thank you very much, Lucy. I'm going to speak a little bit about principles for remote advocacy, and I very gratefully accept the advice in a very helpful note from an organisation called the ICCA. That's the Inns of Court College of Advocacy. They've produced a 13-page document headed Principles for Remote Advocacy. You can find that online at icca.ac.uk. For reasons of brevity, but more importantly of copyright, I haven't been able to attach it to my slide, but it's worth reading. I'm trying to understand the technology. There are 8 principles for remote advocacy. Some of them Lucy has already referred to, so I won't say much about them. The first is liaise in advance, which Lucy has spoken about a lot, but which I can't really stress enough. Really, it seems to me that although there are 8 key principles, the reality is that there's actually one key point in effective advocacy for remote hearings. And then that key point is that actually it's not very different at all from effective advocacy in any hearings. Because we've always, lawyers, in general, barristers in particular, have always done the same thing, which is they've always tried to present their case to a decision maker. And the key point is whether and how to persuade the decision maker that your client's position is correct and or that the other side's position is incorrect. That's what we do when we appear in a physical court. And that's what we do when we appear in a virtual court building. And it's no different. The fact that we're doing it from home or from somebody else's offices or from a foreign country because we went there 6 months ago and chosen not to come back is, to my mind, neither here nor there. We're still doing the same thing as advocates, and more importantly, perhaps, judges are still doing the same thing as judges. They're still receiving arguments from 2 sides orally and mostly in the work that we do previously in writing, coming to probably a provisional view and then having argument on top of that and refining their views. All of those things are not obviously new. The way in which we speak to each other now is new, in that we are using technology, in that we're not appearing in the same room to do the talking part of our jobs. But that's the, to my mind, those are the only things that are really new in remote hearings. So whilst, as you've heard, and as you all know, no doubt 100 times better than we do, about the logistics of remote hearings, and Lucy's explained some of them, particularly with reference to bundles and with reference to litigants in person. Nevertheless, I think it's very important that we don't let the technology drive our concern into the actual hearing, and let the technology overtake what is just the normal key preparation that you have to do. So whilst there are these 8 principles, in my view, the real key principle is to think about how, as advocate or as part of the advocacy team, you can do what you need to do, which is to promote your client's case above the other client's case, and persuade the tribunal who you're appearing in front of that your position is correct. So with that in mind, you will, of course, liaise in advance, mostly with the other side, but also with the court, because that's the person you're trying to persuade, the court. And Lucy's made a number of very good points about bundles. Judges can sometimes be thought of as getting, to use a neutral phrase, a little grumpy about bundles. My experience is that judges only get grumpy when they can't find things, and not being able to find something is obviously not good for your case, so you don't want it to happen. So as Lucy said, make sure the bundle is easily searchable. It's not too long, even if it's electronic, entirely electronic, and so you're not putting 5 lever arch files on somebody's desk. It's still a distraction to have 1,200 documents in a bundle and only actually refer to about 15 of them, because the problem is that before you get to the hearing, the person who's got those 1,200 documents may have thought they need to read them all. So liaison, really, it's key with the court, in my view. Understanding the technology. Well, we've all had the position of being on mute when we don't think that we are, pressing the wrong button and ending up on mute, turning our cameras on and off and all the rest of it. That basic attempt to understand how to control simply your own voice settings and your own visual settings is obviously important. Lucy mentioned the importance of being on mute and the importance of not being seen when you don't want to be seen. And equally, I would say one of the most important things about the technology that we all have probably come across by now is if you have a hearing and too many people are on screen at the same time, the bandwidth just fails and the picture slows down and the sound slows down. So it would be helpful to think in terms of how many people do I actually want to have on the screen at any one time. Judges will sometimes say to you, look, well, the only people I want on the screen are the people who are speaking, and everyone else, please go on mute and please turn off your cameras. But that's part of understanding the technology. The other thing that you clearly need to do at all times, and you may see now that I'm looking occasionally away, is you need to have more than one screen. There are 2 main reasons for this. The first is because you need to have a screen to talk to, and you need to have a screen with your notes and or your trial bundle on. The second reason you need to have 2 screens is in case one of them breaks. Because of course, when you're dependent on technology, it's like the girl with the curl. When it's good, it's very good, and when it's bad, it's horrid. You so never depend on your technology. My extent of not depending on technology includes, despite the fact that I'm notionally paperless, having paper notes for all hearings in case all of my technology fails, and notes get lost, which would be clearly a problem. So do understand the technology, and as importantly as understanding the technology, in my view, is to understand the limits of the technology. 3, make sure all parties can be seen and heard. Well, that obviously speaks for itself. The ICCA's first note under this is, as far as possible, the online hearing should emulate a traditional hearing, and that applies to advocates and witnesses alike. Clearly, if you can't be seen and heard by the judge, you're not going to make much of an impression, and certainly not a good one. Likewise, if your witness can't be seen and heard, that's not going to help either. You need to make sure that the parties can all hear each other as they need to during the hearing, and the judge can hear everyone, and you need to make sure that you can be heard clearly. That may again go back to the technology. Some people use headsets, some people use earbuds, some people don't, they just try and speak into the screen like I'm doing now. Occasionally, for reasons which are way beyond my understanding of technology, it simply doesn't work. And you just have to start again. And we've all, I'm sure, been in hearings. I was in one recently where in the middle of a hearing, we simply had to log off and log back on again because for a reason totally unknown to anyone in the middle of the hearing, one of the parties suddenly lost contact with the rest of, with everybody else. So it's not just making sure that you can be seen and heard at 10:29 a.m. It's making sure you can be seen and heard throughout the hearing. Don't think it's in any way odd if people keep asking, can you hear me? Can you see me? It's better to know than to be talking to the void. Do remember, as well as being that, making sure that you can be seen and heard, make sure that you cannot be seen and heard, as I've already said. We've all had horror stories, either of our own or of colleagues, or been involved in hearings where someone has spoken out of turn, either thinking they were on mute or simply, I suspect, forgetting that they could be heard. And they've said things which are inappropriate or unnecessary, or in some cases even unhelpful. Remember that what we're doing is we're emulating a traditional hearing. And of course, in a traditional hearing, people who might be talking under their breath would be some distance away from anyone else and talking quietly and not heard. But if you're on a microphone on a computer or an iPad or equivalent, and you're talking quietly, if you're not on mute, you will be heard. And you will, it will be embarrassing at best, and it could get worse. So do be careful about that. Obviously, cases excite the emotions in people, notably, of course, the clients, but also occasionally parties have some emotional involvement in their own cases. That's normal, but it's all part of being professional, is to avoid that. And if you can't avoid it, make sure you can't be heard when you're expressing what might be otherwise described as strong views. Point 4 is knowing how to handle the documents. And Lucy's talked about e-bundles. You may not be using an e-bundle. You may be using a hard copy bundle, but other people might be using an e-bundle, and maybe a combination of them. So when you know how to handle the documents, don't just know how to physically pick them up and use them, but know where things are in the documents. And also try to check before you start, for example, making any notes for cross-examination, the document pages mirror each other, by which I mean the PDF page in the top of the screen can sometimes be 2 or 3 pages more or less than the actual page number on the bundle, because when they're being made up, they don't take account of indices, for example. You just need to try and make sure that you've got the right page references. Again, because you want everyone to find them, and you don't want your judge to get upset about them. And the reason why you would have 2 screens equally is so that you can handle documents whilst talking to to the witnesses or to the judge. The next point is a key point, making the best use of written arguments. If there is a downside to remote hearings, it is that judges will inevitably make more of what they receive in advance of an oral hearing. So if you're putting in a skeleton argument, as most people do now for even small hearings, make sure that it's clear and concise. And probably, if you don't do this already, on the first page of your written argument, summarize what you say should be the outcome of the hearing with a couple of reasons in a paragraph or possibly 2. It's obviously part of advocacy is written advocacy as well as oral advocacy. In my view, written advocacy is only going to get more significant as time goes on, not just in the higher courts, but in all courts. And it's absolutely key that you use your written argument to provide what the ICCA describe as a clear roadmap of the issues and how you expect to approach them. Also, if you can provide a judge with a reading list with page references at the front of your argument, so much the better. But I can't stress enough how important, to my mind, is a good written skeleton argument in the days of remote hearings. And then when you do get to your oral hearing, be prepared, be brief, and to the point. Remote hearings, sometimes it is said, lack the urgency or the power of an oral address in court. People feel, rightly or wrongly, that it's less straightforward to make an impression when you're just peering at a screen than when you're actually looking someone directly in the eye in court. Whether that's right or not, I'm a bit of an agnostic about. But one thing is certainly true, that these hearings, as we all will know, are tiring. They're tiring on the eyes and they're tiring on the brain. And nobody is going to thank you, least of all the judge who you're trying to influence, if you go on a bit or a lot, because for the reasons I've already given. So do be brief, be to the point, and remember that being brief, as the old saying goes, I wrote you a long letter because I didn't have time to write you a short one. It takes longer to prepare a case in a brief way than it does to simply, for example, read the judge through a lot of documents. So everybody needs to allow themselves more time to prepare for remote hearings than perhaps they used to do for hearings in the room. Be to the point. That's the same as being brief, frankly, but it's absolutely key. 7 is avoid overspeaking. That means try not to talk when somebody else is talking. Sometimes, as you know, these platforms have different speeds for different people. You might think that somebody's finished talking when they're not. It's just really about etiquette and manners. You wouldn't overspeak in a regular court hearing, so don't do it in a non-regular, in a remote. Finally, maintaining confidentiality, and Lucy talked about that. But again, it's key to remember that we are in a court hearing, that we will be looking at documents which don't need to go anywhere else, talking about things which don't need to be broadcast to the public. It's important to remind people who are appearing or are on the call, like clients, that they mustn't make their own recordings of court hearings, because that, apart from anything else, is a criminal offence. But those are the eight principles. Next, I just want to spend literally a few moments on this point. Is virtual cross-examination any different to quote-unquote real cross-examination? And obviously, we'll be cross-examining two groups of people: witnesses of fact and experts. We've probably all now, in the last 13 months, had experience of watching or taking part in cross-examinations in a virtual trial, in a remote trial. To my mind, actually, they're not different in any serious respect to a normal cross-examination. And it goes back to the point I raised earlier, on which I'm a bit of an agnostic, which is about whether it makes any real difference whether you are in the same room as someone or not. I've heard it suggested that if you can't, to use an expression, eyeball the witness, the cross-examination is more difficult. I'm not sure that's right. If you are on the screen and the witness is on the screen, in many ways, there's actually less places to hide on the screen than there are when you're in court. Witnesses now, if they're giving evidence in a remote hearing, will be on their own, often either at home or in a room on their own, or in a room, say in a solicitor's office, but on their own. And you can't look at your friends at the back of the court. You can't look at your own team to see if they're smiling at you or not, as is normally the case. It's actually, in many ways, it seems to me, it's harder to be cross-examined as a witness than it is in court. The same goes for experts. I have heard it suggested in some quarters that expert evidence has actually got better in virtual hearings than it was before, because experts, again, because they're not in the room with the clients, are more happy or more willing to give uninhibited and expert evidence. Again, I don't know if that's true, but when you're preparing a cross-examination, it doesn't seem to me that it's different to a real what used to happen in court, other than taking in mind the point I've already made, which is try to be brief, if you can be, in your cross-examination. Try get straight to the point. If there are really 3 issues that you want to address with a witness, address 3 issues, don't address 6, in the hope you might get somewhere with some of the others, because you'll lose your tribunal before you get to the important one. So in my view, actually, real virtual cross-examination, so-called, isn't that different to real cross-examination. And in some respects, it's better, it's easier. Virtual platforms, well, Lucy's mentioned them, and by now we're all familiar with them, and I'm talking on one of them now, and you're listening to me on one of them now, which is Zoom. Zoom main features, notably the screen share, helpful Q&A and chat, can be helpful, but be careful with chat, because depending on who you send your chat to, you might send it to the other side, or even worse, to the judge. Teams is very popular with a number of organisations, and I know that a large number of solicitors firms will only use Teams, for example, because of issues or perceived issues with security in Zoom. Teams features are fairly similar. Quite a lot of platform. The court has its own platform, which is beginning to be rolled out. But at the moment, I think its functionality is not as good as Teams or Zoom. And most judges will be quite happy to use something else. The roles building courts tend to be adaptable to anything. They used to be using Skype almost exclusively. Skype for business, as we now know, is Teams. And so courts now have largely moved across to that. But be aware that one of the advantages of a virtual platform, what I've described as the add-ons. So you can have your bundle as part of your virtual trial. Some organisations like Opus Magnum provide bespoke trial packages, where, as well as having the screen to see people, you can have the bundle on the screen, and you can have live note. You can have simultaneous live note. You also receive transcripts in the evening. They're all hyperlinked. The transcripts are hyperlinked to the bundle, and so in an appropriate case, probably a bigger case, because these are very expensive systems. But in a bigger case, you could have really all of your trial done virtually and through one of the platforms. So that's probably with it. Practical issues. Well, we've raised most of them. The real practical point here is remember what it is that you're actually doing at all times, which is advancing your client's case. Remember not to be able to be heard when you don't want to be heard, or to be seen when you don't want to be seen. Keep it brief. Speak up. Try and look the judge or the witnesses in the eye when you are talking to them, and be prepared. I hope that's been helpful. Thank you very much. We'll see if there are any questions for Lucy or I to answer. Lucy's going to come back on the screen. So we've had a question about consequences or concerns of witnesses and experts having external help or materials that aren't visible. Most, I think Lucy mentioned this, but most tribunals now, probably at the pre-trial review stage or at the beginning of a hearing, will establish a protocol, which is that witnesses need to be in a room on their own and to confirm they're on their own, and that they don't have any, as well as no one else in the room, they also don't have any other notes. This again is a common, to my mind, a common concern that we always used to have in cases where witnesses, or particularly experts, would turn up in a witness box with a stack of papers, and someone would say, well, what are they? And the witness would say, oh, they're my notes. And you say, well, you can't have those, so give them back to your solicitor or whatever. So it's not a new point. Some judges, some tribunals have asked to see the room that people are in, to make sure that they are on their own and there's no one standing at the back with cue cards and the like. But largely, I think now people are used to the idea, and people do, by and large, behave appropriately. So that's my answer. I don't know if Lucy's got anything to add to that.
Thanks, Andrew. Yeah, I agree with that. I think it's a point that can be addressed at the PTR quite usefully, so that the judge reminds everyone of the protocol. It's difficult because in the usual course, as I said, and we've all had experience of, witnesses may take a note of corrections they want to make in the witness box. And in the usual way, as an advocate, you'd probably show that note to your opponent before you call your witness, so that everyone knows it's just a list of paragraphs where there's a typo or they want to change something slightly. But obviously that's a million miles away from there being a big sheaf of notes available to a witness, or worse, that you feel that they're communicating with someone. I've had a trial where there was a concern on our part, and the WhatsApp messages were flying backwards and forwards between my client solicitor. They were watching very carefully a witness who did seem to be looking up towards someone else. I think the reality is, if there is a suspicion of that, the appropriate, and there is a real concern as to what that's going on, I suspect the appropriate course is once you've communicated with your advocate that you've picked up signals that something is amiss, for the advocate to just ask the judge to stop making submissions, and ask the judge to just raise those concerns with the judge, be open about it. That would be my advice. As I say, I've been close to that. But it's a fairly unusual situation, and I think you probably know it when you see it. So that would be my view. I agree.
Thank you, Lucy. I had a question early on, which I'll deal with now, and while I am, perhaps Lucy would have a think about a question about hybrid trials and how they work, and whether you think they do work. But whilst you're thinking about that, I'll just answer the question that was raised early on about arbitrations, where there are written reports and replies, and what point and why would an arbitrator call a hearing, and whether a remote hearing achieves the same ends as a in-person hearing. Well, arbitrators are, as you know, very used to dealing with matters remotely, in the sense of not having long or any oral hearings. So I've, for example, arbitrated disputes which were entirely dealt with on paper. That's not unusual to me. It's a normal event. Equally well, you can sometimes have arbitrations where the arbitrator would say, well, I'll have written submissions, I'll get all the evidence in writing. I even have then some closing submissions, but I may then decide to have half a day to ask questions of the parties. To my mind, that you would only do that if you really, as arbitrator, if you actually did have some questions you needed to raise. But if you do, I don't see any difference between having them as remotely or having that in person. In fact, remotely is a way I've done it myself in the past, and I would no doubt do it again. Which leads me to a point I did want to raise about remote hearings, which is that they are clearly here to stay. The judges, by and large, like remote hearings, particularly for what we used to call interlocutory matters, but also in trials where there are either not a lot of factual evidence, or the factual evidence that there is won't take very long. And it seems to me that we shouldn't think that when, in due course, the COVID restrictions lapse, that we will suddenly be straight back into having all of our hearings in a courtroom in front of a judge, because we won't. That's why I think it's important to bear in mind the principles of preparation and advocacy at remote hearings, because they are here to stay. With that, I'll now ask Lucy to address the question about hybrid trials, please.
Yes, we've got a question. How do we think hybrid trials work? Some of the evidence from witnesses virtually and some in person. It's one of those things that everyone talks about, possibility of a hybrid trial, and then they don't, generally they're quite unusual in my experience. They can work. I think there's no reason why they shouldn't. If you're all in court and the main witnesses, as you say, are in person, but the minor witnesses from home, as long as the same protocol has been given to them about having the bundle and making sure they're in a private room or so forth, then my experience is the court will make sure that that link works and they're readily visible and can participate fully in the trial. And as long as, I mean, the judge will certainly take steps to make sure they feel they can participate, and that should work reasonably well. I mean, an interesting point is also, I'm told to start my screen, sorry. Sorry. One interesting point also is that it may well be the point about people attending. It's not necessarily main witnesses who are needed in person, but obviously bearing in mind that the issue of people travelling to court is, in my experience, the predominant issue which affects whether they can come or not. So you may get people who are reluctant to travel through absolutely genuine concerns about the current situation, depending on age and whether they've been vaccinated, and the difficulties of travelling to a major city and all of the contact that takes in place. So I wouldn't assume, as I say, the only comment I make, I wouldn't assume is that main witnesses are going to be in person, but minor witnesses from home. It may in fact be the other way, and there's no reason it shouldn't be. That's really all I would say on hybrid trials. They can work reasonably well, and I think as long as everyone's practical and the point is addressed at an early stage with the judge, there shouldn't be a difficulty. And as I say, I don't think there's any reason why there shouldn't be contact, as long as you know who the trial judge is or know the possible pool of trial judges are, to communicate with the court at an early stage, identifying we have these problems. Take a poll of your witnesses as to who can attend and who can't, and address it that way.
Thank you. I think we've covered most of the questions now, and I noticed that we've got to after 10 o'clock. So I think now will be a good time to end this seminar. As I mentioned at the beginning, the seminar is being recorded, and the slides, both our slides, will be sent out probably later today. Thank you very much, all of you, for attending this seminar. One thing that we've noticed, and I'm sure you have too, is that the remote world does allow some considerable scope for larger seminars and to reach a larger audience than the previous world of sitting in a room in King's Chambers in one of our locations, or somewhere else for that matter. So, for example, at one stage, at the peak of the viewing this morning, we had about 250 attendees, and we're very grateful to each and every one of you for doing that. But also, it does show that you can get a lot more people who can spend part of their day in a seminar without having to travel. And we hope that you all enjoyed it and that you got something out of it. And we hope you will continue to enjoy our seminars, our webinars at King's Chambers. And all that remains is, on my behalf and on behalf of Lucy, to wish you all a very good rest of day, and take care and stay safe. Good morning.